Hi there, I'm Savannah Mexto with Manor Law Group, and I'm excited to welcome you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Manor. This week's webinar is all about retirement accounts. What really is a retirement account? Why does it matter? And why do retirement accounts require a different kind of estate planning? We'll be answering all of these questions and more on today's Webinar Wednesday. Now, before I pass the torch to Bob, I'd like to cover just a few housekeeping details. First of all, a quick disclaimer, and Bob will cover more on this later. Today's webinar will be informative, educational. You'll definitely learn something new, but you're not going to receive specific legal advice. I encourage you, if you're looking for advice unique to your situation, to contact us after the webinar. Also note that today's webinar is recorded. We'll send out a replay tomorrow of today's webinar that you can share with your family and friends. If you have questions at all during today's webinar, please put your questions in the chat box. We will be saving time at the end of today's webinar to go over those questions. If for some reason we don't get to your question during the webinar, we will reach out to you afterwards. Now, why should you listen to what the folks at Manor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys Michigan chapter. Lastly, Manor Law Group has been honored by our readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Manor.
Hi, folks. We're going to get right into this. So here's the agenda for today, and it's going to be pretty straightforward. That's I have a typo. I see it says why is a retirement account? It should be what is a retirement account? What is a retirement account? Why is it different than other assets? What options do we have for planning for retirement assets, and what do you do now? What's the next step? So I think it's very important to acknowledge sometimes it's actually pretty confusing about what a retirement asset is, and it doesn't seem like it would be, but we're going to try to cut through some of that. But I noticed this, and the reason why this comes up is that I'm talking to clients every single day, and I have to talk to them about their assets and what do you have and how much do you have in each account and what type of account it is. And many times, in fact, probably most times, people aren't entirely clear on which ones are considered retirement accounts and have to be planned for differently, and which ones aren't considered retirement accounts. So I think it's an important topic because it really is something that people aren't always that familiar with. And honestly, it doesn't seem like it would be that important, but it really is because those accounts have to be handled differently. We use beneficiary designations a little bit different. We use trusts a little bit different. We use wills a little bit different as it relates to those retirement accounts. And so it is important to distinguish those and to be able to communicate about them and know the difference between them. And it's not always clear on the face, so people will bring in their statements. They have their investment statement. And most of the time, I can look at the investment statement and say, yes, this is a retirement account, or no, it's not. But it's not always actually clear on the statement, especially if it's an annuity or sometimes even other types of accounts. So let's get right into it. We always have this disclaimer. This is just your standard thing that says, look, if you're acting on legal advice you get from a public webinar, then you are maybe not taking what's in your best interest. You presumably wouldn't try to perform surgery on yourself after watching an episode of some medical drama or something like that. And this is a little bit different than that, but my main point is we're going to be talking about things in generalities. This is good information, but when we, as far as applying it to your specific circumstances, you should get specific advice about your specific circumstances. All right, so I did a quick webinar, or not webinar, I did a quick video for my clients recently, and I pulled out this old slide from a presentation I did to probate lawyers in Michigan. So I do frequently, I will present for the Institute for Continuing Legal Education so that existing lawyers can keep up to date on different topics or learn new topics. And this is from a presentation I did a couple of years ago. It has a more specific sort of legalistic definition of what retirement accounts are. And so I put that up there in case you're interested or curious, but I'm gonna kind of try to cut through that a little bit. So a couple things. First of all, there's really, let's say, two types of retirement accounts. There's the type of an account where every time you take money out of it, they charge you taxes on it. And the reason for that is because you didn't pay the taxes on the way in. Okay, so those are the type are typically an IRA or 401k, 403b, 457, PSP from GM, qualified annuity, anything where every time you take money out, you got to pay taxes on it. Annuities are a little tricky because if it's a qualified annuity, then they're going to tax you on every dollar that you take out. If it's a non-qualified annuity, then they only tax you on the interest that you've earned on that annuity. So those are a little trickier because you say, well, that sounds like a retirement account because I'm paying some taxes. But the question is, are they taxing you on $1 that you take out, or are they taxing you only on the interest that you take out? It gets confusing because typically when you take money out of an annuity, you're taking interest out first. You take the income out first, and so it looks like you're getting taxed on every dollar, but that's because you haven't invaded the principal yet, what you originally put into it. So the two types, again, just to clarify, is the type that whenever you take money out, you got to pay taxes on it, or Roth IRAs. Roth IRAs are going to be where you don't pay taxes when you take it out. So it seems more confusing. And so with the traditional qualified funds, you pay taxes when you take it out, but not when you put it in. They also have required minimum distributions. Now, if it was with a Roth IRA, it doesn't have required minimum distributions, at least for the first generation. So we're going to talk about what happens after you die on these things. And there's going to be, that's where it gets, that rule changes. But I often will tell people, okay, well, trying to figure out if they have any retirement accounts, I'll say, well, do you have any accounts where you have to take money out every year, where you have to pay required minimum distributions? Well, that's true for your traditional retirement accounts, but with these Roths, you could have a Roth account, which is also considered a tax-preferred retirement account, and there are no required minimum distributions. So answering that first question, do you have any accounts that you have to take out required minimum distributions, that doesn't actually fully answer the question. And sometimes we have to do a little detective work and try to figure out if the account is a retirement account or not. Now, I use that term retirement account because I think people are familiar with, or it's kind of a bigger picture that people are familiar with. That's not, retirement account's not going to necessarily be a term of art in taxes and, with the IRS or in law. It's just more of a broad category. And I think it's important to think about and use terms that people are comfortable with using. So if I go out there, I remember years ago, one of our best team workers, one of our best team people here, our employees, I asked her in an interview to define a qualified fund. And it was an unfair question because she didn't have that kind of background. But my team always gives me grief about that because I ask such tough questions in interviews. And how she answered the question was actually helped her get the job. And so the idea of using perfectly accurate words to describe things such as qualified fund or those types of things, that's fine, and I will do that, and that's what I did when I was presenting to the probate lawyers. But the reality is we've got to be able to talk about these things in common language too, right? We got to be able to talk about them in ways that people are going to have something that they remember. They say, okay, yes, that's these types of funds are a little bit different because they're, they come into this category of retirement fund. So why is it so hard to figure this out? Well, it'd be easy if your statement came and it said IRA, but not all of them do. And it would be easy if that was just the type of account that it was. So a lot of times when I'll ask people the question from the IRAs, they may say no because they don't have any statements in the mail that says IRA, or they have one that does say that, and they'll say, well, this is my IRA. But when I dig into it, it turns out that they have a CD at the bank that's an IRA, and they have an annuity that's an IRA, and they have, you know, an IRA is not the type of account. It's actually the nature of the account rather than the type of account. So the type of account could be anything. It could be any kind of investment and be an IRA, practically any type of investment. There's even ones where you can invest real estate in an IRA. It's pretty rare, but you know, I've seen them, and that's definitely something that some people do, that they have real estate in their IRA. So it's not the type of, it's not whether it's a CD or a mutual fund or a annuity or you know, other type of investment account as to define whether it's an IRA or not, or a qualified fund or a retirement fund. So it really is, the best way to describe it is, did you set it up under the terms of the tax code that either you didn't have to pay the taxes or you got a tax deduction for putting the money into it, or that you set it up so that you put it in after taxes, but when you take the money out, you don't have to pay taxes on it, including any interest or income that you've earned on it. So so it gets a little bit confusing, I'll admit that, and it is kind of hard to explain. But the ways that we usually look at it is, for the traditional types of accounts, we say, well, where did that money come from? You know, if the money came because you saved up, you know, $300 every paycheck, or you saved 10% of your paycheck and you just set it aside and then you invested it after it got into a certain amount, then that's probably not a retirement fund. But if it came because it was a program that was set up at your office where you worked, and they had, you know, maybe they contributed and you contributed and it just kind of grew, and then when you retired, you rolled it over into another account, well, that's going to be a retirement account. Okay, right? No matter whether you rolled it over or not. The buyouts, you know, a few years ago, all the companies, especially the auto companies, were offering buyouts. So they had actually set that you were going to get a monthly pension. And for some of the people that get monthly pension, they said, oh, you know what? Instead of sending you a check for the rest of your once a month for the rest of your life, how would you like it if we just give you a lump sum of money? And that was a big decision for people to make. And a lot of people did make that decision. They took that lump sum. Well, that's going to be a retirement account. Even after they give you that lump sum, that's going to be a qualified fund, meaning that you have not paid taxes on it yet. And when you start pulling that money out, you've got to pay taxes on it. In a minute, I'm going to explain why this is so important. And then, of course, the other option was that you specifically invested in an IRA. In other words, you were contributing to it, not necessarily through work, but you can do it through the bank or through whatever, and you were contributing to it so you could pay lower taxes in that year. So in 1998, you had decided that you wanted to contribute $2,000 to your IRA because that was going to be $2,000 less that you'd have to pay taxes on, maybe to try to lower your tax bracket, or, you know, there was lots of good reasons for doing that. So that's typically where that comes from. As far as the Roths, that's typically one of two things. Either you had a traditional IRA and you converted it into a Roth, that's probably the most common, or you just started contributing to it. And so you didn't get a tax deduction for contributing to it, but when you take the money out of it, which you probably should do last. So if you contribute to a Roth, the idea is that's the money we maybe want to spend last, because whatever money's in there, it's going to grow tax-free for the rest of the time that it's in that account. And so typically we don't want to spend our Roth IRA money first, because that's the money that can grow tax-free and we never ever have to pay taxes on it. And so that was either, you know, for a Roth, it's typically that it was a conversion from a traditional retirement account, qualified fund, or it was that you contributed to it over time with the understanding that when you take the money out, no matter how much it's grown, you don't pay taxes on that growth. Okay. So I know it's more of a technical question, but I'm going to explain now why it's so important that we talk about that. First of all, kind of sticking on these definitions, just for a second here, we'll stick with these definitions. This is an account that is an individual account, whether it's a Roth, whether it's a 401k, whether it's 403b, whether it's an IRA, whatever it is, it's an individual account during your lifetime. What that means is it has to be in your name and it has to be in your social security number. So sometimes people think that they can have their IRAs and they can put their spouse on there or they can put their kid on there. No, you can't. Can't do that. Now there's a difference between putting their name on it and using a beneficiary designation, okay? Putting their name on it means that either party has access to it during your lifetime. Well, for these types of accounts, it's an individual account. It has to be an individual account. So you actually cannot add a name to it, meaning that the other person has access to it. Now you could add them where they have access as power of attorney. You could have add them because they have access through a court order. But they don't have any ownership of it. It's an individual account. They are not a co-owner of the account. You can't put your spouse as a co-owner of the account. Of course, you can put them as a beneficiary, or we can talk about using trusts and things like that. But that's one of the clear distinctions about these types of accounts, that it's an individual account. It's actually one of the clues that I look for when we're trying to do that detective work to see if it's a retirement account or not. So I look at your statement you get from whatever financial company, and it'll say, okay, well, these accounts are joint between husband and wife, and these ones are not joint. As soon as I see that it's not joint, it tells me that's a clue to say that's probably a retirement account, because retirement accounts have to be in one person's name, an individual, while you're alive. Well, we're going to be talking about for the rest of the time today is what happens after you die, because now there's all kinds of options. And sometimes people they don't want all kinds of options. They just say, tell me the answer. Just tell me the answer. Just cut through all of this. I don't need to learn all of this. Just tell me, what is the answer? Well, I have good news. I can finally, after 20 years of practicing law, if we set up your planning right, I can give you a straight answer. Because the straight answer now, under the new law that passed and took effect January 1st, 2020, is if we set up your planning properly, and it's probably not set up properly right now because it's a brand new law. So don't take this as the answer unless we update your legal documents. But once we update your legal documents, then the answer is we can wait and see. That's the best answer, right? Why is wait and see the best answer? First of all, you don't have to sort through all of the possible options here. You don't have to sort through that. We can wait and make the decision when we have all of the relevant information. So we don't know when you're going to die, right? We don't know how much money you have in that account. We don't know what type of account it is. We don't know, have you taken all that money out? Has that money gone? Is it invested in a different way? We don't know any of that stuff until you die, right? That's just that information, unless you can predict the future, that information is not available to us. So the best time for making the decision about how we want to get taxed and how we want it to move on is at the time of your death, when we can gather all of that information and then make the right decisions. Now, there's still going to be a whole bunch of options and a whole bunch of decisions, but that's when, with proper advice, proper legal advice, financial advice, then we can make sure that your family gets the best benefits out of it, pays the least amount of taxes, gets the best option, gets some protection potentially, so it's protected from divorce and bankruptcy and lawsuits and all that kind of stuff. And so that's the time to make that decision and make sure that's set up. And so what we really want to do now is change your will, change your trust, change the beneficiaries in such a way that's going to defer that decision until we have all the relevant information. This is one of the benefits of the new law that I don't, initially, honestly, when I heard about the new law last year, when they were talking about signing this, I was disappointed in the law. I thought it was going to be a bad idea, and it is bad in that for many times we have a 10-year rule, and we weren't limited to 10 years on paying that retirement account out in 10 years previously. Well, we still might not be. And this is where this chart is very helpful to say, okay, well, what happens after you die? So there are a lot of people think, if you've done any research on this, you think that basically what it means is you're going to pay out that account within 10 years. But even if we stick in this yellow column of paying out in 10 years, there's a whole lot of questions we have there. Okay, do we pay it out all right away? Do we wait 10 years and pay it all out, which is a possibility? Do we pay about out a little bit, 1/10 every year for 10 years? That's a possibility too. These are all, possible solutions. And honestly, you should not be making that decision now. And if we make that decision now, it may turn out to be very financially bad, because it could very well mean that you're going to pay way more in taxes as a result of trying to make the decision before you have all the relevant information. Okay, so we know that after you die, one possibility is we have what now the law refers to as designated beneficiaries, and that's going to have that 10-year rule. Okay, then, and so it's not even very clear. It says non-spouses in certain trusts. So again, it's not very clear, because you see certain trusts on all three of these. And so what we have to make sure is that your trust is set up so that we can pick and choose which is the best option at the time. Okay, so designated beneficiary is going to be that 10-year rule. Here's where the real danger is. Okay, if we don't update your documents and we don't have it comply with the Secure Act, we might end up falling into this non-designated beneficiary area, the red area over here. Okay, this could mean that Uncle Sam gets more of your money and your kids get less of your money. Okay, so this is particularly important. This is why we think that this is worth an update of your legal documents. And yes, there's some cost involved in updating your legal documents, and this happens from time to time. They change the law. There's some good parts of the new law, there's some bad parts of the new law, but what we really don't want to do is end up in a situation where we end up being forced to pay the taxes sooner, meaning that we could end up having to pay more taxes because we'll be in a higher tax bracket. But what's interesting is this third, actually on the screen it's the first column, but the third one that I haven't gotten to yet, which is the green section, which is eligible designated beneficiaries. Okay, so now we're getting interesting. Okay, so we talk about minor beneficiaries, we talk about disabled persons, we talk about the chronically ill, we talk about people that are not more than 10 years younger, spouses, and again, certain trusts. Okay, and so the idea behind this, what we've come up with for updating your legal documents, we want to have all of these options. Well, we want to get rid of the red, but we definitely want to be able to pick yellow or green, depending on what the circumstances are at the time of your death. Okay, and I'm going to show you a slide where we kind of have this flow chart where it helps us make the decision as to, or to give you advice about how to do that. But the idea here is, prior to 2020, January 1st, 2020, we had to try, under the old law, we had to try to predict the future and try to figure out, okay, how exactly do we want this set up? If we want it to be a charity, that gets, a little, under the old law, that got really complicated. If we wanted it to be partly a charity, if we wanted to have the charity as the backup, that got complicated. If we wanted to have it go partially to a disabled person, we had to specify that separately. What we're going to do now is we're going to be able to say, okay, everything's going to go upon your death to the trust. Okay, so that's actually a really key phrase that I just said that I would never have been able to say before, and I still can't say until you update your legal documents. Okay, we don't want you to follow this advice until you update your legal documents. But once we've updated them, so we've included all of these options, then what we're going to do is we're going to say the beneficiary is the trust. Well, what's interesting about that statement? Why did I say that's so interesting? Because what did I tell you earlier about retirement assets? They're individual accounts. They have to be in one person's name. They can't be in a trust during your lifetime. Okay, I'm going to repeat that. Remember earlier I said individual accounts, retirement accounts are individual accounts. They have to be in your name. They can't be titled into your trust during your lifetime, but they can be titled into your trust upon your death. And if we update your documents now properly, then we can just make it easy and say the beneficiary of a retirement account is the trust. Okay, and then we make sure all of the options are built into this trust to make sure that it can go to the spouse, it can go to minor beneficiaries, it can go to disabled persons, it can go to chronically ill, and we can use the best stretch, the best option that's available at that time, but depending on who the beneficiaries are, how much there is, what types of accounts, when you died, all of these things, just to make it more flexible to be able to decide how to distribute that upon your death. And even even if it does go into the 10-year rule, then giving advice with regard to, okay, each of those beneficiaries need to be thinking about, okay, that 10-year rule. First of all, we can have asset protection for that time period so that it's not subject to divorces and creditors and all those types of things. The second thing is giving them advice about how should they be taking it out. Because a lot of people would just be like, okay, well, I take it out over 10 years, I'm gonna take 1/10 every year for 10 years. That may turn out to be a really bad decision in a lot of cases. And so the good news is we don't have to decide that now. We can wait and see what's appropriate, what are the circumstances, how old are your kids when they receive it, does it go, any of it go to the grandkids, does it go to the spouse, does it go to the grandkids, and we can even to some extent decide that later on, because we can use what's called disclaimers. So you might leave it to your kids and the kids say, you know, we're gonna save a ton of money on taxes if they bypass me and it goes on to the grandkids. And so we're setting it up so that we can use disclaimers also. So that is the idea here, just to confuse you a little bit more. Not really trying to confuse you, but this is sort of the inside planning for you know, determining beneficiary designations on these. And so you see we've got, you know, different options here. One of them is the outright to the beneficiary, which provides no asset protection and really very little options for making sure that we have the best planning available. So we go through this. This is sort of our internal dialogue within the office about, you know, in discussing it with your family, which of these options, how are we going to go through this path? You know, do we want to use any disclaimers so that we're going to bypass somebody, have it go on to their kids so that they can tax it at a different tax rate and maybe over a longer period of time, and all of these decisions. Okay, so this is kind of our internal process for thinking through, upon your death, if we have the planning right and we have the beneficiaries right, we can go through this dialogue to see you know, how to set that up and give them the best advice possible. But from a planning perspective, we're looking at this. So these are all the, remember earlier we had, I'll go back to that screen to show you, we had the eligible designated beneficiaries, this green section, okay? So in this one, these are all eligible designated beneficiaries: spouse, minor child, disabled or chronically ill, less than 10 years younger. So we're gonna have special benefits for them, right? We're gonna be able to stretch those out more than we would stretch them out if it was anybody else. And so then we've got the non-eligible designated beneficiaries. And so this is for you know, the planning. And so we're talking about, you know, okay, do we want it to be into a family trust or common trust, separate share trust for each beneficiary, providing for some, at least protection for some period of time, so it's protected from you know, like I said, divorce or creditors or those types of things. And also it makes it so that it's going to be easier to give your family advice with regard to how and when they should take those distributions and how and when they should pay the taxes. Okay. So what, if I had to guess, I would guess that some folks that see this presentation today are going to say, you know, I really thank you, that was really good information, but it seems like a whole lot of information, a whole lot to digest, and a whole lot of decisions to make. And that's really where our point is. I really think now, under the new rules, I always say every time they try to change the law or simplify the law, it basically just makes it so that you need the lawyers and the accountants more. Every time they simplify the tax code, it means that I'm going to pay my accountant more that year, because it's just the fact. It's every time they change the rules and every time they change the law, it makes it more necessary for me to get good advice. And I think this is very true with regard to this new Secure Act. So why is this important? The first, going back to the original thing, you know, what is a retirement account? Well, if you don't have any retirement accounts, or your retirement accounts, you got $30,000 in retirement accounts and everything else is not retirement account, then none of this really matters. Honestly, if it's just such a small amount of money, $20,000, $30,000, something like that, it's a small amount of money. I know $20,000, $30,000 isn't really a small amount of money, but in dealing with taxes, it's not going to have a major tax impact. Then we don't have to worry about any of this. And maybe we don't even update the documents. But if we have a decent amount, and a lot of people do, in fact, the statistics tell us that most people have most of their savings and investments in retirement accounts. That's where their money is, especially people under a certain age. If you're under, a lot of people older than 70 have a lot of money in retirement accounts, but particularly those under 70, under 60, often have most of their money, because us folks, the younger folks, if I can still call myself a younger folk, the younger folks, we don't get pensions. We don't get monthly pensions, and we never will, probably. Hopefully we'll still get Social Security if that's around when we retire. But many years ago, most companies switched off of offering defined pensions, what they call a defined benefit. And the defined benefit would be you're going to get a monthly pension of this amount for the rest of your life, no matter how long you live or how short you live. Well, most companies moved away from that because that's really difficult to plan for, and we saw lots of companies going bankrupt over that kind of thing, and caused all kinds of problems. Good idea. It was nice when it was there, but most younger folks, younger meaning under 70, and I guess 70 is still young, but younger folks aren't going to have that opportunity to get a monthly pension. So most of us are going to have the bulk of our savings in some kind of retirement account. And so this is going to be really important, and it's complicated. I guess it just is the bottom line. It is complicated. If you're going to make the right decision, you're going to have, when we go through the flow chart, it potentially could be hundreds of options of looking at, the specifics. I don't know, hundreds, but a lot of options, and a lot of those options are actually pretty complicated. And my point on it is, boy, I know that people don't necessarily like going to see their accountant or like going to see their lawyer or those types of things, but I don't like going to the doctor either. I don't, but I do it because I say, okay, if I go to the doctor, then my life might improve. If I go to the accountant, I might pay less in taxes, and so it's worth it. And so what that means is we got to plan now. We got to update your plan now, and we got to be around when you die. And that's we've always I was looking at work that I had done 15 years ago, and it's amazing how much progress we've made and how different the firm looks from 15 years ago. But pretty much from 15 years ago, and that was probably about the time that we started thinking in this direction. Our idea was that we'll be around even after Bob's not around. We'll be around even after I'm either retired or gone or sitting on a beach somewhere or anything else, because I'm still pretty young, I think, and I'll probably be around for a while, and maybe I'll be the one sitting with your family when something happens, but the idea is for us to be there at the time of your death so that we can give the right advice. And that's a little bit of a shift of thinking, because I think a lot of people thought, hey, we're going to see Bob now, we're going to see Manor Law Group now, because we want to make it so that they don't have to deal with lawyers and all of that afterwards. And my answer is, you're right. We don't want to have to deal with the court system or have lots of lawyers or a lot of things involved, but I still think they're going to want proper advice, and it's going to be in everybody's best interest to make sure that that they get advice after your death too. Because now, especially under the Secure Act, we're going to have so many options and so many choices. It's not going to be intuitive. It's not going to be automatic. And so you're going to need us after your family is going to need us after you die too, because there's going to be so many options, and it's not just going to be, oh, well, just write everybody a check. Everybody kind of thinks that, I think people still think that. I did a video a few weeks ago about myths that we learned from movies. And everybody just kind of thinks that you show up at the lawyer's office and the lawyer hands out checks, 10 days after the death. And it's never been the way that it works. And particularly now, and so because people think that, a lot of families think, oh, well, after dad dies, after mom dies, I just go to the bank, get the money, and why do I need the lawyer? And the answer is, well, now it's getting more complicated. Should follow all the rules, make sure the person you put in charge, the executor, isn't going to be on the hook for anything or have any personal liability. But now more than ever, that's always been a case of saying, okay, let's follow the process make sure that you're not going to have any liability. You do everything right. We dot every I, cross every T. But now more than ever, I think we're going to need you're going to need our advice after you die, or the family should. And sometimes the family doesn't understand that because that's not a big topic of conversation. But hopefully we can get that message across, because potentially it could save people thousands and thousands and thousands of dollars in taxes if they handle the distribution properly, which is going to be very difficult to do if they don't know and have explained to them all the options that are going to be built into your legal plan once we do these updates. Having said that, we're going to see if we have any questions, and we'll come to the questions in just a second, but there is one thing that I want to cover. Not sure that we have any questions, but we'll see. What should I do now? I want to tell you, if you're a client of Manor Law Group, we got you covered. What I mean by that is that just yesterday we sent out emails, and we will be sending out more emails, and we'll be getting a letter in the mail outlining the process for updating your documents. Okay, so we'll be contacting you. We probably have already contacted you. If you're not a client, maybe you should be. And so if you know folks that have retirement assets, I can almost guarantee you they have not built in all of the options, no matter who was their lawyer, whether it was us or somebody else, but particularly if it was somebody else or they don't have any planning. So we would really appreciate it if you send them our way, because I think we're at the forefront here. A lot of attorneys are still struggling with the Secure Act. I think we really got our heads wrapped around it. I think we've got probably better planning than just, it's just really good planning to create it so that we can have all these options and wait to make all the decisions until we have all the relevant information. So having said that, we're going to go back to, do we have any questions, Savannah?
Hi, Bob. I don't see any questions at this time. So if you do have a question, now's the last call. Go ahead and put that in the question in the chat box, and we'll be more than happy to answer that for you before we wrap up today.
Okay, so assuming there's no questions, or if there is in a second, then I'm going to let Savannah wrap up here. But the idea is that, like I said, if you're a client, that you'll be getting separate instructions. So if we did your will or trust, you're going to get separate instructions as to how we're going to get a hold of you to update your documents and what that process is going to look like. And we've got options there, so you can. There's, where we schedule a meeting and we go over and explain everything. We've got one where we just change the documents, which we don't recommend, but some people they don't want to pay too much attention. They just say, just update my documents. So we have that option. And then we've got one other option. So that's all going to be explained to our clients. But so the instructions that Savannah's going to give you are, if you are not an existing client, and you want to be, and then that would be great. We'd love that. And she will talk to you about a process for scheduling that. You can actually use this process if you're a client too, absolutely. So she's going to explain what that process looks like to get a hold of us and get some questions answered. I'm just telling you that you will also be contacted separately, or probably if you get email, if you do email, which I assume if you're on a webinar, you probably do email. But if you do email, you probably already got an email yesterday, and you'll be getting more, and there'll be something in the mail. If you're not a client of ours, then you're going to want to contact us to make sure, even if you had a really good trust drafted, we're probably going to want to update it for these new law changes. All right, Savannah, it looks like maybe we do have a question.
Yes, we do have a question. So if you're 35 or younger and have designated beneficiaries for your IRA account, will that likely be sufficient?
Yes, maybe. Okay, so if you're 35 or younger and have designated beneficiaries for your IRA accounts, whenever I get a question, I'm always looking for, what are the red flags? Because it seems like an obvious question, but what are the red flags? Somebody who's 35 or younger might have kids, and if they're minor beneficiaries, no, that's not going to work. You might list your spouse. Okay, great. That shouldn't be a problem to list your spouse. But what if you and your spouse die together? Okay, well, now we maybe have minor beneficiaries. Okay, well, that's a problem. What if your beneficiary is your parent? So now you're saying I'm 35 and under, but my beneficiary is actually 70. Okay, that might be the answer, But my suggestion is we at least take a look at it to say, okay, that's an answer. Here's the other option to use a trust, so that if it does go to your parent because you don't have a spouse or don't have kids, then this is how, we got to make sure that it's protected for nursing home and all those types of things, or that they have an option to disclaim it and have it go on to your brothers and sisters or whatever the scenario is. But somebody, typically when I hear 35 or younger, I'm thinking, oh, maybe they have kids. And if they have kids, those kids are probably going to be minors. That means that just having listing them as beneficiaries will create a problem. Listing a spouse is probably not going to be a problem, although if you do more planning, it creates the option of the spouse managing it for the younger kids and choosing to do their tax bracket instead of the spouse's. So I know it should seem like a simple answer. It's just not. It could be. I mean, it might be. It is a reasonable answer. I'm not going to say it's a bad answer. It's a reasonable answer. There just might be better options for paying less taxes, depending on your circumstances. So, good question. Very good question. All right.
Yes, thank you. We don't seem to have any other questions today. So I think we're safe to go ahead and wrap up. Now, as Bob mentioned, well, first of all, I want to say thank you to everybody for coming, because I know this is a really great webinar. It's if you don't know about it, you don't know about it. And so I'm encouraged by stuff like this. And as Bob said, we do have a way for you to get in touch with our team. So an email should be going out to you within the next few minutes. In that email, you will have a button that you can click. It'll take you to a calendar, and it will actually let you choose a day and a time that's convenient for you to go ahead and have our team give you a call. And the call will just give you a chance to ask our team a few questions about us, about our process, and really interview us to make sure we're the law firm that you would like to help you with your planning. And it also gives our team to ask you a few important questions too. Questions about your situation, questions about your goals, and what type of help and concerns you have. So at that point, we'll be able to know, A, if we're the best law firm to help you, and B, which attorney you should meet with. We actually have 3 attorneys on staff, and each one kind of has their own little specialty. So depending on what your needs are, you'll be meeting with the best attorney for you. So again, that email will be coming to you shortly. If you would like to meet with our team, the first step is just to click the button, schedule a day and a time for us to give you a call. And then from that point, we'll go forward and have you meet with an attorney, or we'll let you know who the best other person could be to help you. So we look forward to working with you. If you ever have any questions, you can also give us a call at 810-694-9000. Thanks so much for attending today, and I hope you all have a great day. We'll see you next week.